I was giving Henry's speech at Agincourt about 3 minutes ago. We few, we marry few, we band of brothers and sisters. It's updated. And all of a sudden you come.
Once more into the breach.
Yeah. Pledge of what? I haven't done it in 7 years, except on the floor of the house, so. No, I mean. Opening the hearing of Tuesday, May 23rd on the special committee on the family division of the Circuit Court of Appointments are the ones who are here. And all I'm going to read by way of introduction, you all know that there have been several iterations of this kind of committee, and we've heard that, so I just have to read the notice and disclaimer. The Special Committee on the Family Division of the Circuit Court was formed to investigate allegations of irregularities, including failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. The committee will conduct hearings relative to the process of the family division of the Circuit Court and may make recommendations for future legislation. The purpose of the committee is to discover areas where changes in procedures or changes in law regarding the family division of the Circuit Court might be made. The purpose of this special committee is not to retry cases of citizens who disagree with the outcome of litigation. Members of the public will be given opportunity to testify and present information to the committee. Because of the number of people who may wish to testify, there may be a time limit imposed on each person testifying, which is permissible under House Rule 100. Appropriate subject matter for testifying will be limited to specific instances of where there seem to be irregularities in process, procedure, or adherence to rules and statutes. And I want to emphasize that. If you come up here and talk in generalities, it is not helpful to us. You will not influence us because you've not given us anything to consider. Make it specific to a case and the specific problem you had with what went on and so on. Those testifying about subject matter related to a court case or who submit documentation related to a court case should know that both will be made part of the public record. Therefore, subject matter that is either confidential or may be under seal should not be discussed or submitted to the committee, as disclosure of such matters would be a violation of statute or of a court order. And the committee reserves the right not to accept written or oral testimony or materials which would, in its judgment, violate the foregoing. And with that, our valued committee researcher, who is up first to make a presentation to us? The New Hampshire Court Improvement Project. I thought we were the New Hampshire Court Improvement Project. Good to know you.
Good morning. Good morning, Chairman Person. Good to see you. So my name is Susan Ashley. I'm the Deputy Administrative Judge for the Circuit Court here in New Hampshire, and I am here today to assist on discussing the Court Improvement Project, But first and foremost, I would like to introduce you all to Christy Lamont. She has been working for the Court Improvement Project here in New Hampshire for 27 years. She started when she was 12, but quite a long time. And she is most certainly the expert on the Court Improvement Project. So I will let her have the floor.
Good morning. I really appreciate the chance to be here. And what I'd like to do is provide a brief overview of the New Hampshire Court Improvement Project. And then Judge Ashley is going to describe one of our more recent initiatives related to permanency hearings. So in terms of the Court Improvement Project, we are 100% federally funded. Our funding comes through the U.S. Department of Health and Human Services, the Administration for Children and Families. And as a federal grant, I have a federal representative in Boston with whom I work closely. He and I together work on federal requirements for the Court Improvement Project, what the national initiatives are that court improvement projects are encouraged to consider. And also he's available to answer any questions or address any concerns I may have. All states have received court improvement project funds and have created their own court improvement projects. So New Hampshire is part of this national movement that began in 1994. Nationally, the purpose of the Court Improvement Project is to improve child welfare outcomes. And there are 3 parts to that. And I'd like to share those parts with you and also talk to you about how New Hampshire has responded to those parts. So the first part is collaboration between the judicial branch and the child agency and as applicable tribes. And in New Hampshire, beginning in 1994, when the Court Improvement Project funds were accepted in New Hampshire, collaboration for us has been one of our strengths. There's a very, very strong collaboration between the court system, DCYF. We've expanded that to all stakeholders in child protection matters. So that includes the Attorney General's Office, CASA of New Hampshire, the Judicial Council, Office of Child Advocate, DCYF, and also parent attorneys. So all of our work that we do is multidisciplinary, and those groups are represented on our efforts. Again, national purpose to improve child welfare outcomes. The way we do that in New Hampshire primarily has been around court protocols, developing court protocols. And I'd like you to refer to the second handout. So we're developing court protocols really with a goal of consistent practice in the circuit courts throughout the state. Consistent practice, procedures, process. That's the goal of the court improvement and also of our protocols. And when we talk about court protocols, by that what we mean is we've developed a document that includes federal law, state law, New Hampshire Supreme Court cases, and also nationally best practices. So anytime we refer to court protocols, that's what we're referring to. All of that work we're bringing into court protocols. That second handout that we gave you, that's a picture of what's on the judicial branch's website related to abuse and neglect cases. And you can see there we've developed a number of protocols. I know it's small, but if you go to the judicial branch's website for abuse and neglect cases, this is what you'll see. We also included on the website links to trainings that we've developed. When we develop protocols, we often develop a video training just because there's so much turnover for all the stakeholders. So these training videos are available. They're between 6 minutes and 50 minutes, but they're a great introduction, high-level overview of the protocols that we've developed. I just want to highlight a couple of the protocols on that second handout. The first one is protocols relative to abuse and neglect cases, and that's really the foundation of our work.
Excuse me, what does this look like? I'm drowning in paper.
The second handout.
Got
The
it.
col-
Thank
yes.
you.
Yeah, absolutely. So the
Where it says protocols, yeah.
yes.
okay.
Yeah, that's okay. So the protocols relative to abuse and neglect cases, that's work that we began in the late 1990s. We rolled it out in 2000, and actually I have it for you. This is what it is. These are our court protocols, the initial effort of the Court Improvement Project. There's a chapter dedicated to each hearing type in abuse and neglect cases. And it's really the first guidance that we've had in New Hampshire for all of the stakeholders as they prepare for court hearings. And it's also guidance for the courts, for judges, so that they, again, consistent court practice. We want consistent court practice throughout the circuit courts in New Hampshire. And so this guides them in that regard. The last, at the bottom of that page, it says 2012 protocols relative to children and youth in court. That's an example of a national initiative to encourage children in court to come to court hearings. We've heard nationally that kids want to be part of the process. They very much want to meet the judge, have an opportunity to come into court. It's their option. They're not required to do it. If they'd like to do it, they're able to come. And so we develop protocols to set out what that would look like, how kids would be invited to court, when they came to court, what that process would look like. So those are our children and youth in court protocols. The third handout I'd like to refer
Could
to
we
now.
stop on that handout
Sure.
and see if there's any questions about that so far? Who inputted to you for this document? Who'd you talk with?
So again, multidisciplinary committee. So we had courts, input from courts, from DCYF, from parent attorneys, from the Judicial Council, from DC, I think I said it's DCYF, and CASA of New Hampshire. So as we develop them, the way it works is we have multidisciplinary committees that develop these protocols. And it's not only the group that's convened, but we really encourage folks to take back to their stakeholder group questions, concerns, drafts of protocols, and then we came together to finalize the protocols.
I didn't hear an individual appearing pro se, some of them to input, because their experiences, we've learned, can be somewhat different.
Sure, absolutely.
Sure. So just to clarify, the cases that the Court Improvement Project is focusing on are abuse and neglect cases.
Okay.
And so while we have many, many, many self-represented litigants in divorce and parenting cases, domestic violence cases, all of those types of things, in our abuse and neglect cases in New Hampshire, almost everybody has attorney representation. Of course, the agency has attorney representation, but the parents, by and large, have attorney representation, except if they're a non-petitioned parent. So the statutes in New Hampshire do not allow the court to appoint an attorney for a non-petitioned parent unless they're a household member. And so there are some folks who do not have counsel, and they would be those few self-represented folks who are coming to the abuse and neglect cases. But all of the petitioned parents, everyone who is petitioned with an abuse or neglect case, they have the right to court-appointed counsel.
Madam Vice Chair.
What's a petition parent?
Thank you for that question. So if the Division for Children, Youth, and Families, after doing an assessment and an investigation, believe that they need to bring a court case to address the abuse or neglect. In other words, they don't believe that they can assist fully with protection of that child outside of the court process. Then they will file a petition with the court, essentially asserting that the mother and or the father or both have neglected the child, and they'll explain how, or have abused the child, and they'll explain how in that petition. It is not a criminal case. These are civil matters, so they are petitioned into court for whatever that case is. And sometimes it is both abuse and neglect. So one case can have multiple petitions.
Representative Long.
Thank you, Mr. Chairman. Just for clarification, it references children and youth, abuse and neglect. Are youth 16 consistently 16 and older? And children are 15 and below?
We don't really necessarily define what's a youth and what's a child when we talk about children and youth. It's just that sometimes we recognize that the 17-year-olds don't like to be called children, so we might use that broader phrase of youth. But there's no specific definition. There are certain laws that do specify what we can order for a permanency hearing, for instance, for someone who is of a certain age. And but other than that, there isn't a specific definition of child or youth.
Okay, and a follow-up if I may?
Follow up.
Thank you. I saw a reference 16-year-olds. So are some statute or some of the understanding that
Yes.
a youth will be 16?
Let me answer that. I think I've got a clearer answer than what I gave before. In a case when we get to the point after a parent is petitioned and a finding is made of abuse or neglect, then and the child or youth has been removed from parents' care. Generally speaking, there's some asterisks to that, but generally speaking, the parents have 12 months to resolve the issues and hopefully reunify. If we get to that point and we're having a permanency hearing, then if the parents haven't satisfied the statutory grounds to have that child returned to them, then the court has to select a different permanency plan than reunification. There is one permanency plan, and there's only a couple of options: adoption through termination or surrender of parental rights, guardianship, or what we call APLA, another planned permanent living arrangement, which is a mouthful, but APLA, by federal law, can only be ordered for a youth who is 16 or older. So that's where you're seeing the 16 reference, and we have a small number in New Hampshire who fit into that category, and so we often refer to them as our APLA youth.
Very good. Thank you.
Any other questions from anybody? Yes, way down the end there.
Thank you. And thank you for taking my question. I just want to clarify about the protocols. I think that it was the first witness that said they're based on federal law, case law, statutes, and best practices. So is there really, these are a roadmap for everyone, attorneys and pro se. So there's not really a lot of public input into these. These are kind of objective points that need to be hit, correct?
Yes, that's correct.
Thank you.
And I would just add to that, to the extent DCYF has parents with lived experience, they would bring that feedback to us. That's how we would get that information from parents.
Thank you.
You may continue.
Great. So the third handout, and this fits very nicely, the third handout is, in addition to developing protocols, the next step for us is to say, are there court forms that we need to develop to support the protocols, support state law, federal law? And so we often develop forms, we develop standard court orders. Again, consistent practice is the goal for us. And so I've included the notice that goes out to a petition parent. So a parent against whom yes, that's the one. We also have two other forms very similar to this, one for a non-petition parent who's a household member. So that non-petition parent living with the petition parent. And as Judge Ashley said, that non-petition parent, the court has the discretion to appoint that non-petition parent an attorney in the abuse and neglect case. And the protocols strongly, strongly recommend that courts exercise their discretion and appoint that non-petition parent an attorney. So this is a great form. This is another roadmap. This is the form that a petition parent would receive. And again, a non-petition parent who's a household member gets a separate form. And then we have a third form, very similar, for a non-petition, non-household parent. And it walks them through the process very, very well. Section 2 is their financial responsibility. That's on page 1. Section 3, again, this is a petition parent indicating you have a right to a court-appointed attorney. Roman 4 is telling that petition parent that your child is going to be appointed a guardian ad litem in this case. And then on the back page, Section 5 is a request giving this petition parent information about a request that a non-petition parent could make. And that request is that if we have a non-petition parent in an abuse or neglect case, that parent is able to say, I'd like my child to be placed with me. And if there's an objection to that by DCYF, what that results in is the court scheduling what's called a parental fitness hearing. And at that parental fitness hearing, the judge is going to decide if that non-petition parent is fit or unfit. If the court finds that the non-petition parent is fit, then their child is going to be placed with them. Section 6 is...
Question.
Sure.
So far, was that your hand or not?
You go ahead.
Okay. Under the ad litem, I was under the impression that the parents in question have to pay for the guardian ad litem, or is that only in divorce cases?
So this is the guardian ad litem for their child.
Who pays?
But yes, in abuse and neglect case is, again, very different from the divorce parenting arena. In every abuse and neglect case, the court is required to appoint CASA, a CASA volunteer, as the guardian ad litem for the child. So there is never a cost to the parents. To answer your question, there's never a cost to the parents for a guardian ad litem in an abuse and neglect case. That is very different from a divorce parenting. We have to appoint CASA if there is a CASA volunteer available. Sometimes they do not have enough volunteers available. Then we would appoint what we refer to as a private guardian ad litem, in other words, a non-CASA guardian ad litem. And the Judicial Council pays for the cost of that guardian ad litem in the abuse and neglect case.
Thank you. Representative Smith.
Go ahead, same question.
Okay. Would you take the same answer?
So then, Romans section 6 is an explanation of the court hearings and the process. And this is information that the hope here is that the parent will have an attorney, and that their attorney will review this form with them with special attention to the court process, what is going to happen at each hearing type. And then on the last page, it lets parents know, again, the petition's been filed. This is an overview of the court process. The last page lets them know that they're going to have this opportunity to correct. Service is going to be provided by DCYF. And if they don't correct the conditions that led to the court's finding, that's assuming that the court makes a finding of abuse or neglect, then the division may file a petition to terminate their parental rights. So they're told all of this information at the very beginning of that abuse and neglect case.
How far ahead of time are they told?
When the petition is filed.
Okay, right away.
And they're served with the petition. That's sort of the beginning of the case, when they're served with that, the emergency order, if there is one, but then with the petition. This form goes with that service packet, so they'll have that as soon as they get any information about the case. But then, as Christy was indicating, at the first hearing, when they talk with their attorney, they'll be reviewing it with them. And then the court reviews this information with them on the record at the first hearing. So there's several opportunities for them to understand.
Are they served in the same way a process server would serve anything?
The police departments serve these petitions as opposed to the sheriff's department. Generally speaking, in New Hampshire, that is the way, because they're in touch with the situation a little bit more carefully. So that's the local law enforcement is who receives this information, and then they bring it to the parents.
What if the person refuses to take the packet?
Then their law enforcement would reflect that they left the packet with them, and they would let us know that.
Toss it at their feet, consider the job complete, and walk away.
Well, I don't know, because I don't do the service. But again, these aren't criminal cases, so there wouldn't be an arrest of that parent.
Right.
It's their child that there's an allegation who's been abused or neglected. We want to have the parents involved, because ultimately we want there to be permanency for the child, make sure the child is safe, and then make sure that we are achieving permanency. So it's important to have the parents involved, and they may not initially choose to be involved, but we will continue to make efforts. The court is making those efforts. The agency, DCYF, must make those efforts to continue to get all parents involved.
So there's a presumption that they'll probably receive the packet when it's offered to them, but in case not, there is a very immediate way to say, we have done due diligence on this. They are without excuse.
Yes.
Thank you. Representative Katab.
Thank you, Chairman Pearson, and thank you, Judge Ashley, for taking my question. So just so I'm understanding correctly, for there to be a finding of abuse and neglect, would this be done through a judge, or are you saying when DCYF may have a finding of it? I just want to understand at what point there's actually a finding, if it's through a court hearing and then this 12-month clock sticks after the court hearing, or if it's through DCYF.
It is, so I am referring to cases that are filed with the court. So when DCYF files a petition with the court, then the court will ultimately, the first hearing is that preliminary hearing, but then we'll be scheduling the adjudicatory hearing, which is, as I tell the parents, this is the trial on the actual merits of the petition. And if the court finds abuse or finds neglect at that point in time, that's really when the clock starts ticking, because it's by statute, by New Hampshire statute, it's 12 months from that adjudication date, when that order goes out. Except if there's a request for an early permanency hearing. There's always the asterisk, so there's now statutory exception. We might have time to get into that later.
Thank you.
Representative Long.
Thank you, Mr. Chairman. I see this form was January 1st of 22. Were there forms prior to this? And how often would you upgrade to when you hear of problems with parents trying to understand it?
We're always revising. This form was not initially made available in 2020. This is just the 2020 version is just the most recent version. So, and it's a great question. Anytime we develop protocols, Judge Ashley and I revisit prior court forms, court orders, and say, what do we need to update? Where do we need to update it? We also do that based on feedback we get. Just anecdotally, we're always soliciting feedback from our multidisciplinary group and from the folks they hear from to say, bring us information. And we spend a lot of time updating forms and court orders.
Great, thank you.
Yeah.
Representative Lanza.
Thank you, Chairman, and thank you for taking my question. Do you have these forms in different languages as well? Because I know many people within New Hampshire are from different backgrounds and stuff and have don't all speak English.
We do not. That's the issue of forms is an area that we are continuing to try to improve upon as far as what we have for availability and what our technological capabilities are. But any forms that, of course, are filed with the court or the court orders have to actually be in English. So those are sort of our standard forms have to be in English. We would like to have the ability to have them translated into other languages, but at this point, they're all in English, and they're generally all on our website. Again, the link that that first document about that lists all of the protocols is one page of the court's website. There are other links on the website that do include the court forms, so you can kind of go through those and look at those forms if you'd like to as well.
Follow up?
Just
Or
one other
another
question.
question.
Do you have translators available within your court system for these people that do not only speak English?
Yes, we do. Thank you for that question. Anyone who needs translation services, of course, for any court hearing would be provided that. And then if there's anyone who needs that beyond, either if they're up at the window, we have the ability to contact someone who can translate for them and assist in that capacity. Thank you.
You may continue.
Great, thank you. The other form that we included is, it's called DCYF's Affidavit to Identify and or Locate a Parent, Guardian, or Putative Father. So that should be behind the notice form. As you move through the packet, it looks like this.
Okay.
So we wanted to share this one with you because a significant emphasis of the Court Improvement Project has been around missing parents. And by that, we mean when a petition is filed against a parent, we may have a second parent who is unknown. Their name, we may have their name, we may not have their address, we may not have a name. So the ongoing obligation of DCYF is to continue to look to identify and or located that missing parent. And so as we developed protocols, we also developed this affidavit. And it's an affidavit that comes into the judge before every court hearing at which there's a case involving a missing parent. It's a significant issue not to have both parents involved, engaged at the beginning of the case. So this is a great example of collaboration between the court system and DCYF. We have protocols, we develop protocols on missing parents, what needs to happen when there's a missing parent, and then what does happen once that missing parent is identified and located, the importance of getting that parent served and engaged, bringing that parent into the case and into court hearings. So this is a great example of we developed missing parent protocols, and then we said, how do we support those? And we said, let's develop an affidavit. And this affidavit was developed after extensive research of what other states are doing around affidavits. What are other states doing when there's a missing parent in an abuse or neglect case? We don't want that case to just continue without ongoing efforts by the division to identify, locate that parent. So this is the affidavit that comes into the court before every court hearing with a missing parent. Gives the court an opportunity to know what is the division doing? What has the division done between the last hearing and this current hearing? And then an opportunity for the court to engage DCYF in a colloquy around the importance of those ongoing efforts and what they should look like between the current hearing and the next hearing. Again, huge significance. So important to get both parents identified, engaged, and involved in these hearings as soon as possible.
Representative Katab.
I see that this form, thank you, Mr. Chairman. Thank you for taking my question. I see that this form was created in 2020. Was there a form prior to that for this, or did it just start? Did this initiative just start in 2020? I just want to understand when the initiative started.
Great question. This is not the first form. This form actually began as a DCYF form. And when we developed the missing protocols, we said we wanted to revisit that form and revise it, improve it, and make it a court form. And the court's expectation is that this form is going to come in before every court hearing with a missing parent.
You may continue.
Great. So the other thing we do, we develop protocols, we develop court orders, forms. The other thing we do is try to evaluate our efforts. And so we've shared with you today some survey results. And this goes to the protocols that we developed coming back to the 16-year-old youth. So for a 16-year-old youth with APLA as their permanency plan, parents were not able to meet the standard for their youth to be returned home. Adoption is not an appropriate permanency plan for that youth. A guardianship is not an appropriate permanency plan for that youth. So we have APLA, another planned permanent living arrangement. And what our protocols set out for is that when the courts have an APLA youth, and at this time there are about 30 of them in the state, so a very small universe, but a universe of youth at significant risk, and we know that. These are young people at risk for homelessness, pregnancy, prison, substance misuse. So as much as it's a small universe of youth, it's a group at high risk. And so our response to that was to develop protocols. And those are the protocols on the court's website. They're called protocols relative to post-permanency hearings for APLA youth. And it's a shift for the court. What we set out in the protocols, we want the courts to have a more informal hearing. We want to shift away from the parties reporting to the courts about the status of the case, and we want it to become a discussion really between the judge and the youth. Again, these are young people. They're 16, 17, 18. They could be out on their own in a very short time. And so what we developed with these protocols, we said, we want to help these young people to develop some life skills. And so we want them to come to court. We want them to talk to the judge. We want them to take responsibility for their life, what it's going to look like at the end of this case, when this case closes, and all of these folks are no longer in their life. So those are the protocols we've developed. And then we said, we want to know how we're doing. Have these protocols achieved one of the outcomes for us? And one of those outcomes is that these young people not only come to court, but they have a positive experience in coming to court, and they come back. That we want them to come back. So there's a survey that they can do online. It's, I believe, 17 questions, short, should take them about 5 minutes. They can do it online. If they do it, they get a gift card because we're trying to incentivize them to complete this and let us know about their experience in court. And so we've just given you some of the results from the question about, did you feel today's court hearing was a positive experience and why? And as you see there, almost 80% of them had a positive experience. And then the other question is, do you plan to come back? Do you plan to come back? And almost 96% of them said they want to come back. And as you look at these comments, you'll see that it does reflect that they're having a positive experience coming to court. They're wanting to advocate for themselves. They recognize the importance of being part of the process and planning for their future. So anyway, this is, again, an example of what we do when we create protocols. It's not only creating the protocols, but it's some effort to find out how have we done? Are we meeting our goal?
Representative Smith.
I guess I'd be curious to know, I'd be curious to know what the other questions are. You said there were 17
Sure.
questions?
Sure. And the survey is online. So that, again, on the webpage, the
Yeah.
survey you can access online. General questions. How old are you? Was it an in-person or remote hearing? Who was the judge you saw today? Is it the same judge you've seen in the past? Which court were you in? Questions like that.
If I could follow up, so then there isn't a question that says, did you feel today's court hearing was a negative experience?
There's not, but there is not.
And is there a question that asks, do you have any suggestions about ways that this could be improved?
Our final question is an opportunity for them to provide any comments they have.
Thank you.
When your testimony is finished and you give us a survey as to how we think you did, what's the gift card we get?
$20.
I would have settled for less, but I withdraw that. I do have a relative. But it's better than nothing. I do have a question for Deputy Administrative Judge Ashley. Reports like this, feedback forms like this, might this be profitably extended more broadly across the circuit court?
Yes.
I know that was a push question.
Well-
It was leading the witness.
We're very fortunate, of course, to have the funding that we do have for the court improvement project for this narrow niche of cases that we handle in the circuit court for abuse and neglect cases. There are efforts that are made to see what we have available for other resources that would allow us to have this similar, not necessarily this type of a survey because this is very specific to these youth, but to have more general survey for court users because we think that we can get a lot of input from that.
Because it seems like now with I was going to say my research, but my research assistant's research, that we're like now the fifth group that's whacking at this in 20 years. It could be a wise investment of money for more forms, for more aspects of circuit court, so that this could be an ongoing process and not something we have to assemble every 5 years or so.
And there may be more information about this later, but there's a pilot project right now for a similar survey, if you will, and we're really hoping to utilize the pilot nature of this that's happening right now to see how receptive folks are to giving that feedback. In other words, how many actually participated in the survey and that kind of information to see if we can then translate that in a broader.
Is this the pilot project that's in one of the rural up counties that had a year of conceptualization and has been actually functioning for about 3 or 4 months now?
The pilot that I am thinking of is the pilot that's going on in Brentwood, with there's some kiosks and there's some technology going on there. There was a grant that was available to institute that, or some grant funds, and so we are hopeful that the report after that process is instructive, not only for the results that came back, but the actual process itself of trying to get the feedback. In other words, was that a good way to do so? Sort of folks who were there in the courthouse.
It's not actually the pilot project I was thinking of. Do you know the one I was thinking of? It's up country somewhere in small county, and
Well, we've got a few pilots going on, and so maybe that's an issue that we can touch base on the next time we come back in.
Could well be. Thank you.
Thank you.
Representative Ball.
Thank you, Chairman Pearson. Just for clarification, this questionnaire, this is just for the children. Is there another one that's for the parents who were involved in the same court?
It's just a survey for youth with APLA as their permanency plan.
Okay,
So
so,
16 plus.
but you are, just to follow up, but you're just said that you are thinking about doing it also for the parents to see, did I understand that correctly?
What I was really referring to with Chairman Pearson is whether or not generic surveys are helpful in getting feedback on all case types for the court. So at this point, there is an initiative to have a survey for cases for parents in the abuse and neglect field, but we could certainly consider that to see if that is something that would be helpful. Likely, we would talk with the parent attorneys to see if they think that that is something that would be a good initiative.
Because the federal grant to fund this committee hasn't come through.
Not quite yet, I don't think.
You may continue.
Great. So what I'd like to turn to now is part 3 of the national purpose of improving child welfare outcomes. And that is for court improvement projects, including ours, to support legal representation for parents, for children and youth, and also for the Child Welfare Agency. That's the one. So it says National Association of Counsel for Children at the top. So what we've done in New Hampshire, what I'd like to focus on is our efforts to support parent attorneys appointed in abuse and neglect cases to represent parents. And we're really, really pleased to be doing this work. Parent attorneys, it's an important stakeholder group for us. It's a challenge because unlike the public defender, this group of attorneys, there isn't a public defender-like organization that oversees parent attorneys in 169C cases. So a lot of these folks are solo practitioners. My understanding from working with the Judicial Council is there are about 70 plus parent attorneys for 169C cases. About 70 plus? Not enough. There's a shortage of attorneys taking these cases. And so what we said, we, as a group, again, a multidisciplinary group coming together to say, how can we support this really important stakeholder group? And what we decided to do was 2 things. The first seems, it's taken a long time, but we have a listserv now. The Court Improvement Project has helped to develop a listserv that's available for parent attorneys. We felt that would be a valuable resource for them, a community for parent attorneys, place for them to ask questions, concerns. And so what we're doing on the Court Improvement Project side is we're using some of our resources, our funds, to pay an attorney a stipend, a New Hampshire attorney, to facilitate that listserv. We don't want to be part of that. It needs to be confidential to parent attorneys, but we made it so that we brought it to New Hampshire. We're paying an attorney so that she'll facilitate it. The other thing she's doing is bringing back to us any themes that she sees as part of that listserv. So again, that's an opportunity for input from parent attorneys. We also hope from their clients' parents, but we very much want her to bring back, not case-specific, no case-specific information, but just the themes. What are the issues, the systemic issues that we could possibly address? So that's the first thing we've done for parent attorneys. The second thing is we have contracted with the National Association of Counsel for Children for that group to develop a 2-day, 8-hour New Hampshire-specific training for parent attorneys. My understanding is it's the first of its kind for parent attorneys. We're also going to make it available to law students, hoping to expose them to abuse and neglect cases, encourage them to go into this work when they graduate from law school. The training is free for law students, free for parent attorneys. All of it is being supported by the Court Improvement Project. And I've given you the agenda for that training. It's going to be, as I say, it's a 2-day commitment. So parent attorneys, it's 2 days, 2 days, 8 hours of training. And it's October 6th and December 1. And this is the invitation that's gone out to parent attorneys. Again, that universe of 70 plus parent attorneys, encouraging them to participate in this 2-day training. And if this was designed after, again, feedback, we love to solicit feedback. So the Court Improvement Project helped to coordinate brainstorming sessions, focus groups with circuit court judges and also parent attorneys, asking them, what are the needs? What are the strengths? What are the weaknesses? How can we develop a training that really is not only for new parent attorneys, but also experienced parent attorneys? There's a lot involved in this work. There's federal law is extensive, state law, there's just so much to learn. So this is the training that's been developed. The other nice thing about it is there are 2 New Hampshire attorneys who are working with the National Association of Counsel for Children, working on the materials for the training. Again, New Hampshire specific. It's going to be a webinar. It's also going to be available for I believe it's a year. So the trainings will be offered this year, and then for the next year, parent attorneys are going to be able to access this training. And again, we've dedicated significant CIP resources to this work because we think it's so critical that parent attorneys be well prepared. You see there's a section here on day 1, adjudication and trial skills. That's something that judges identified as a need and parent attorneys identified as a need. I think everybody agreed that that was an area where there was some room for improvement. And so we brought that to the National Association of Counsel for Children and said, this is what folks in New Hampshire have identified. It's what they said will really, again, the goal here is high quality legal representation for parents in 169C cases.
Yes, Representative Smith, please, for a question.
Thank you very much. Going back to the very first page of this very helpful packet that you gave us, under 2, it says court protocols and training for judges and RSA 169C stakeholders. Have I missed something? I haven't in this packet seen anything about training for judges.
It's a great question. And what I should have said, we do a lot of trainings for judges, to answer your question. We do a lot of trainings. Judge Ashley and I, when judges are appointed to the bench, she and I spend 3 days with newly appointed judges, and it's dedicated to abuse and neglect cases. Part of that training includes court observation. We spend a morning and afternoon in court, and then we debrief the other part of the day. It's an extensive training that we do with judges. We also do ongoing trainings. The judges meet every other month, and often abuse and neglect will be part of the agenda, just our ongoing work, our ongoing efforts, and those trainings go well beyond abuse and neglect.
Follow up.
Thank you very much. I am pleased in New Hampshire that we do not elect judges. I think we end up with theoretically a better quality of judge than if we went through an election process. However, I wonder if you have given any thought to whether judicial candidates have had any experience in your particular focus, abuse and neglect. I'm in this committee, we're interested in somewhat in that and another broad category, which is generally the responsibilities of within the family court, so that we have candidates for family court who have or have not had any experience.
So as part of the judiciary, we don't actually have input into the selection of the judges who are nominated and then confirmed. That's really in the executive branch. So the governor handles that. And what we do when we have a judge who is appointed to our bench is we do these extensive trainings. So as Christy was saying, we will explain all sort of soup to nuts abuse and neglect cases. You are correct that there may be judges who are coming in who don't have any experience with abuse and neglect cases at all. That would have been me when I was actually nominated to the bench, because I didn't have the opportunity to be involved in abuse and neglect cases. And it actually isn't that unusual for our judges to not have experience, because as we've talked about, the people who are involved in these cases are DCYF. So it would be maybe a DCYF attorney, but other than that, on that side of it, we have volunteer CASA folks, and then we have folks who do this parent attorney representation, often sole practitioners. It is very unusual to have broader attorneys involved in our abuse and neglect cases. It's kind of an insular field, if you will. So it is very common that judges who are appointed to the circuit court don't actually have much, if any, experience. Maybe they were a private GAL at some point, and so they had some insight. So they're often coming to this work without much knowledge. What benefits them, though, is that the statutes in abuse and neglect are very extensive. So there's clear statutory guidance from the legislature as to what sort of the rules of the road are. And then we have extensive protocols, as Christy's been discussing here for quite some time. And those are always available to the judges. And then we will do the new judge training with them. And then we're there all of the time for support thereafter. So I have learned from my fellow judges through the years, and now here I am sitting here with quite a lot of experience in abuse and neglect cases. And I'm the one who's answering the questions when folks have questions on the bench. But it is an opportunity for us to continue to educate our judiciary on these important issues. So thank you for that question.
Follow-up.
Thank you. So you've described extensive introductory training at the beginning of the process. Are there, and we're looking now just at abuse and neglect. I understand we're not looking at the other areas in family court. Is there supervision that's ongoing? And is there accountability that's ongoing in terms of evaluation of the judges?
Thank you for that question. So as we mentioned, there's the initial training, but then there is ongoing trainings that we continue to sort of touch upon issues in abuse and neglect cases. And it may be that we're revisiting certain protocols, certain statutory requirements, because we are getting feedback, and we do get feedback from the stakeholders. That is what is most helpful about the collaboration that we have in this field, is that we are able to get some input back about, broad brush input back about how things are going in different parts of the state, because sometimes there are different needs in different parts of the state, resource needs, etc., or doesn't seem like the court staff or the judge is understanding the process. Maybe there's someone new at the security desk and they're not letting the child in, even though the child's going to actually be coming to this particular hearing. So there's always the need for that ongoing loop, the feedback and the revisiting of the issues. And then there is the need to train on the new issues that arise. So when there's a legislative change, for instance, and sometimes we're involved with that legislative process, sometimes we're not involved, but we need to make sure that everyone understands that there is a change in the law, and this is how it's going to impact these particular cases. And I know we're probably well past our time, but the last handout that you have is just one piece of the information that we provided to the court when the permanency statute changed in January of 2022. We provided this handout not just to our judges, but to our court staff, to the DCYF staff and attorneys, to CASAs and private GALs, to parent attorneys, to anyone who would take a piece of paper from us, really, but just to folks who needed to understand that it is complicated. The statute is complicated, but it had very specific and necessary changes that would lead to better permanency for children. And it was going to change the process a bit, including having that early permanency hearing that we probably don't need to go into today, but some significant changes that came out of a legislative committee, and we worked very hard to educate everybody that we could on the issues.
We are out of time, but I do have one final question. Maybe there's one or two more. Representative Gay, you want to be in on this. On the second page of this document, for the Friday, December 1st gathering of your cohort, 1 to 3 p.m. This session will emphasize advocacy for reunification. And Representative Gay, this is an issue that is important to you. So I'm wondering if it might be valuable for you to touch base with Attorney Lamont at some point prior to this, because you're going to go forward with some things on this, I know. So just pointing that out, it's in the training that's going to be given to family lawyers, parental lawyers, and law students. Well, with Representative Long for the last question.
Thank you, Mr. Chairman. With going back to this training, 70-plus attorneys for parents, which is not enough, is there any reach out to other states that have attorneys practicing in this abuse and neglect for this training? Or
Yes and no. What I can tell you is the woman we're working with from the National Association of Counsel for Children, she's done similar trainings in other states. So she's bringing that experience to us. We always are interested, our starting place always is, have other states done something that we're interested in doing? And if they have, we want to know about it, we want to build on it. So we've looked at other agendas that this group has done in other states. I mean, all of that has been part of the review process.
okay, follow up for me?
Follow up.
Yeah, I'm thinking more of the border states, especially up north, Vermont, Maine, if they're coming in practicing in New Hampshire. Do we reach out to them for trainings?
It's a great, I believe we plan to. We haven't yet done that, but it's a great question. We're actually meeting next week. I meet on a regular basis with the woman from the National Association of Counsel for Children, and we're always talking about how can we bring this to more people. We want to advertise in the Bar News. So we want to go well beyond the outreach to the 70 plus. Great suggestion. Thank you.
Thank you.
Representative Macbeth.
Thank you, Mr. Chairman. It'll be quick. Is there a fee cap on the amount of legal fees that these attorneys are paid? And what is the average hours that these attorneys spend over the 12 months? Thank you.
Great question. There is a fee cap, and that is by court rule that was recently increased as far as the hourly rate, so that we are hoping is going to prompt some more folks to be able to afford really to do this type of work, because we haven't seen anyone yet really getting rich with this type of work, but at least they're certainly very good advocates for their clients. I don't think I can speak to the average that the average amount there, whatever the cap is, often they're pushing beyond that, but they can't bill for whatever they're pushing beyond that. So the rates they have improved, I guess I will put it that way. They have improved, and that just happened last year. So we've yet to necessarily see the needle move much, but we're hoping that there will be some new folks coming in, particularly, as Christy said, trying to get this into the law students, to have them interested in this type of important work.
If I could just add, there is a cap depending on the hearing type. And we've worked very closely with the Judicial Council around that cap. I think, for example, it's 5 hours for a review hearing. So it's not a lot of time if you consider the prep work before the hearing, the work in the court hearing itself. So we've had a lot of conversations with the Judicial Council around that. How many hours per hearing type?
Representative Kutab.
Thank you, Mr. Chairman, and thank you for taking my question. Would you be able to provide us with, what those caps are and what the financial cap, I guess, ends up being? Just, for example, you mentioned that there was a 5-hour cap for the review hearing. What does that equate to financially? I know, for example, when we heard about the involuntary admission ones, it was $150 cap. So I'm just wondering what the financial amount is, if you know.
We can definitely provide you that information. We'll get that over to you. Thank you.
And with that, thank you so much. We may be
you.
bringing you back if we wake up in the middle of some night and had a question we wish we thought of when you were here. We'll give you a call. You don't have to answer your phone in the middle of the night, however. So thank you for coming.
Thank you for all the questions. Appreciate it.
So now it looks like we do not have another presentation from an agency, and we can move right into pink card questions. And before we do, a couple little business items. There is no meeting of this group next week. No meeting May 30. There will be a meeting on the 6th of June under Vice Chair's leadership. I will be with Marissa Henn from DHHS. We are Milbank Fellows, and we will be having our cohort meeting in Seattle. On June 13th, I think that's going to be court day, and we are slowly finding out where and when and who and how, and can we come early to look around at things, and can we stay a little later and ask some questions? So Ms. Dyer will be keeping us up to date as she knows these things. I will be leaving today at 11:30. As you know, the British Vice Consul will be speaking in Reps Hall at noon. And as a graduate of a British university, I've been invited to meet with him ahead of time, so I will be ducking out at 11:30. With that in mind, Chair recognizes Melinda Nicolosi. None of you attest to being Melinda Nicolosi, okay? Then we will go with Attorney Paula Wormy. She's not in the room. That's okay, she'll come back. And now for Donald, it's either Gilbert or Gilbert, depending on where you're from. And he was Gilbert last week, so I'm gonna go out on a limb and say it's Gilbert this week. All right, welcome back. And you know the rules of 5 minutes, and make it important.
So I did go ahead and request 10 minutes upon that if I could be proceeding with that, but we'll take it in stride.
Okay.
So good morning. Thank you for hearing this testimony. As such, I've been here prior and I'm here yet again. So you heard over the last few weeks several instances. You heard from Director Rimsa from DCYF himself blame the division for a lot of the shortcomings in the family division, a lot of these delays and continuing flaws of our courts. Simply, a lot of constituents are blaming the judges when reality is it is indeed DCYF.
We must get to practicalities, specifics.
Thank you. So again, the main issue here is that takes up these courts hearings is 169C and chins and delinquencies for DCYF. As we heard already, DCYF attested to the fact that they are continuously waiting on criminal aspects on why they are delayed or why 169Cs or chins or delinquency is delayed for one reason or another. As you also heard, that the issue in my own is post-conviction therapy that cannot be afforded to me. As you also know, there's a statutory obligation to reunify or terminate within 12 months to provide permanency for these children. My case has been going on for 3.5 years. The mother in this case with the child separated has been going on for almost 22 months now. DCYF has recently admitted they have no grounds for termination with myself. There is no criminal aspect to my case. There never will be a criminal aspect to this case. That being said, there is a criminal aspect on the other end. Moving forward, back in 2020, May of 2020, to start this off, DCYF originally did not provide that the non-accused parent have a position in this case for one reason or another. Obviously, that was during COVID. It came to a point where we exhausted all options for placement of this child. No foster homes, no residential placements were taking children at the time. So DCYF inadvertently went ahead under 169C 19E and conducted the custody hearing for parents not charged. In that, parents on the accused side and CASA themselves are not allowed to testify adverse information against the parent. The only prosecutorial entity in those hearings for those parents that to be found fit or not fit is DCYF themselves and the parent defending themselves. No other entity is allowed to testify adversely against the parent. What DCYF failed to mention at the hearing to define if the parent was fit or unfit was the fact that back in 2015, one other child nearly died in that household with bleeding on the brain and a broken arm. What DCYF failed to mention is that they closed out 3 open assessments against the mother in attempts to place that child into that home. What DCYF failed to mention to the court is that they have 30 plus other allegations and cases for abuse and neglect against the mother with her other children. What DCYF failed to mention that we did not find out until later on that the house was infested with bed bugs, roaches, fecal
Excuse me, Vice
matter,
Chair?
and urine.
Are you running the meeting? May I interrupt? It sounds like this is testimony regarding one specific case details without is this appropriate testimony? I guess is what I'm asking. It sounds like a disgruntled person talking about a case that may still be ongoing.
Yeah, I imagine, and I am sharing in the absence of the chair. I had not realized what he was doing. I think that the point that my colleague makes is quite relevant. We are not a trial court,
Correct.
as you know. We also are not here in terms of assessing blame or not on DCYF.
Understandable.
What we would like to know is, in your experience in the family court, have you suggestions about changes in procedure based on your experience, and could you provide the documentation for the points that you are trying to make?
That is correct, and that
Thank you.
exactly what I was getting at is the fact that CASA and myself were not able to testify to those allegations that DCYF themselves was failing to admit simply because of COVID being an option, and they exhausted all options for placement. Had CASA and I been able to attest to that, the child would not be harmed. So moving forward with the adjudicatory process, or let me back up further for a second. So obviously with 169C 19E, we need to revise that so that adverse testimony may be provided from CASA and the other party against potentially parents not petitioned. Moving towards to the adjudicatory process in this case, we were not allowed to go forth and have the CAC reviewed by the judge under camera because of COVID.
I'm going to be a good guy and inform you that although you have been at 5 minutes, you're going to get 2 and no more.
Sounds good. Thank you. So going forward, then we will go ahead and speed this up quite a bit. So during that adjudicatory process, the judge did not allow us to review the CAC. During that, we do not know if the judge or did not. That's the only thing I can blame upon the judge, is that we should have been allowed to review that CAC interview. Unfortunately, we do not have grounds for appeal based on that adjudicatory process. The dispositional obviously is for post-conviction therapy that is not afforded because DCYF cannot find a party that is providing post-conviction therapy for individuals that are not convicted. Under 169C31, immunity clause, any party that testifies is immune from criminal liability and civil liability. Moving forward to 2021, the DCYF removed the child from the mother for X, Y, and Z, and allegations of criminal charges that are still pending and criminal investigations. Through this last 2 years, DCYF has continually attempted to try to place the child back in against objection of the judge, against the objection of CASA, against objection of all of the parties and providers for the child. These ongoing issues are still there. So realistically, where we're at is, DCYF is not complying with 169C31. DCYF is not complying with 169C25, which is the confidentiality. There's been a number of issues within this case regarding that. And overall, it has led to this child being re-victimized under the supervision of DCYF. And that's kind of where we're at.
Thank you. However, this is about civil court. This is not a committee about DCYF.
Correct. So that being said, the judge has ordered DCYF to walk one way or another, and DCYF is refusing to follow the judge's orders.
Okay, that still may be off topic, but it is an important thing, and we'll have to figure out what do we do with that information.
Correct.
If
And
anything.
you will have my written documentation regarding this very soon as well.
Appreciate that. And 11 copies, 10 for each of us, and 1 for the files. Thank you so much. And the chair recognizes
Excuse
Stephanie
me,
Hausman.
Mr. Chair?
I'm
I'm sorry. Thank you. I didn't know if there's anyone here from DCYF or from the judicial branch that could respond to the CAC interviews and really who has possession or right to those. There was a lot brought up. I don't know if it's so outside, but it just was confusing. So I'm wondering if that could be clarified by any one of those departments if they're present.
No, I'm not going to allow that to go forward because, again, it is off our topic. Our topic is really the court. The court made a ruling. Someone's beef is with that somebody isn't following the court's rulings, and that's a different topic, perhaps for another committee. I don't want to pursue that.
So I'll be interested in seeing that court ruling because that doesn't make sense to me. Thank you.
That's fair. I'd like to see that too. The chair recognizes Stephanie Hausman.
Good morning, and thank you for your time. My name is Stephanie. Go ahead. You look like you were about to say something.
I often look that way,
Okay.
even when I'm not, but I will, given the chance. Children's Law Center of New Hampshire.
Thank
You
you.
were going to say that.
Yes, I was.
Okay, would you say that, please?
Yes, I'm the litigation director for the Children's Law Center of New Hampshire, which is a new legal services nonprofit that was authorized to commence business at the end of November last year by the New Hampshire Supreme Court. We provide interdisciplinary representation of children. So we represent children who are court involved in either delinquency, chins, or abuse and neglect cases. We also represent them in matters involving special education needs and other legal needs that present themselves to the child. So
And I hope you have handouts at some point. for us.
we plan to come back to this special house committee, and we will have handouts at that time. I'm here a bit unexpectedly because our executive director, I believe, has COVID. So did not want to share that with you. So I've come in her stead. So I come from that perspective, and I also come to speak with you from the perspective of a former foster parent and the current parent of an adopted child that we adopted out of foster care. And one of the things that I wanted to talk to the special committee about in terms of the legal process in abuse and neglect proceedings is that New Hampshire is one of only 14 states that don't provide children with lawyers in abuse and neglect proceedings. And what the research has shown is that children, when they have legal representation in abuse and neglect proceedings, they reach permanency faster. And their outcomes in general are much better. And that's why the National Association of Counsel for Children is working with legislators in New Hampshire on passing amended legislation to broaden the scope of legal representation for children in abuse and neglect cases.
I'm going to ask you to clarify something. You said
Yes.
14 states do have this or don't have this.
New Hampshire is one of only 14 who do not offer counsel for children.
Thank you.
Thank you.
Yes, go ahead,
Thank you.
Representative, please.
So you say that the legislature has proposed legislation on this?
There is a committee that is considering amending legislation to 169C, I think it's 10, which has a very narrow provision by which courts at the moment can appoint counsel for children. Right now, New Hampshire law is that courts can only appoint counsel for children when the child's expressed interest, the child or youth's expressed interest, is contrary to the CASA's determination of what is in the child's best interest. So if there's a conflict there, then CASA is instructed to inform the court, and the court can appoint counsel at that time.
Could you tell us what the bill number is, what the committee is? I mean, we're at the end of this session's legislative process, and perhaps I'm the only one on the committee who isn't aware of this.
If you would let me provide you that information via email after today's meeting, I would
Absolutely,
be
of
happy
course,
to
thank
do that.
you.
Send it to all
To,
of us.
to all of you. Yes, thank you.
Does Chris?
Yeah, go ahead. The chair recognizes our esteemed, stellar, I'm giving you a chance to get to a mic, beyond, non-parallel,
We did see
Go.
a bill, HB 535 in Children and Family did come through on legal representation. And I don't know if this is a provision you're speaking about. You said HB 10. I don't know if that was added to it, but I did do research previously I can send to the committee.
the chair recognizes somebody from Children and Family Law, not being the chairman, who has a better memory.
Thank you, Mr. Chairman. Just to clarify on this, so I believe it's 535 and we've retained it. I think that the language, there was some issue with the language, so we're just working on that, but it is something that we're interested in.
Thank you. And if I said HB 10, I apologize. I think I meant 169C10, which is the current provision by which counsel can be appointed under those narrow circumstances.
So as you look at us and in your mind can tell who's on judiciary from who's on Children and Family Law, you could seek out any of us or them who are on Children and Family Law if you wish to input to us, because we've kept it and they kept it and they're going to work on it. Right?
Thank you.
Thank you.
And I'll just say from my perspective as a foster parent and adoptive parent, when our child was going through this process, she happened to was in agreement with what the CASA was recommending. And the judge in that particular case was very careful also to hear from her. And as the Court Improvement Project indicated to you earlier, they have created protocols about encouraging children to be present at these hearings and to speak with the judges in these hearings, because that is a benefit to the child. It provides the child a sense of agency in a process where they feel like their life is in somebody else's control. And it is a similar benefit when counsel is appointed to represent the child's actual interests, that the child feels like somebody is here fighting for me, for what I want. The child feels like they have some agency and control over their experience. And I know from my own child's experience that was incredibly valuable, and we were very lucky to have the players in the system that she had. She, still sees the judge around town and thinks of him as her judge. And so that has been very valuable for her, and we just wish that more children who were in this process in New Hampshire could see the benefits there. Another point to make.
Could we,
Yes, of course.
the last, the hearing that we heard talked about there's only 70 family judges in the state. About, lawyers, thank you.
Parent attorneys.
About how many attorneys have experience representing children in this sort of thing? roughly?
Thank you for the question. It's a very good question. We've been trying to figure out how often attorneys get appointed to represent children in abuse and neglect cases, and the number is vanishingly small. The next point that I was going to make was that New Hampshire has a lot of really great statutes that protect children's rights in these proceedings. For children who also have special education rights and needs, there are all sorts of statutes that bring in special considerations. There's the Foster Child Bill of Rights, which establishes many important rights for kids in this situation. There are almost no New Hampshire Supreme Court opinions interpreting those statutes that protect the rights of children in these cases, because we have not found a single New Hampshire Supreme Court case that was brought on behalf of a child in an abuse and neglect proceeding. And so these statutes aren't well developed. These statutes aren't familiar to all of the players because there isn't the kind of back and forth about what the statute means and when does it need to be applied, because the Supreme Court isn't being asked to take a look at these particular statutes that deal with the child's rights, because there's nobody in the courtroom at the trial court level, in the family court, that is advocating for these particular statutes on behalf of the child.
Would it be your opinion that when Children and Family Law does a work session on this retained bill, HB 535, it would be helpful to have some of those folks, maybe somebody from Circuit Court, Family Division, maybe from the Supreme, to weigh in on, because I know that the courts ask the legislature periodically, hey, give us something. And would it be your opinion that in addition to yourself being there, a few members of the court system would be helpful to the work we're doing?
I think so. I think so. Again, it's not that the Supreme Court doesn't hear 169C cases. There are 2 points of mandatory appeal in that process, but they are points that are of significance to parents and not necessarily of significance to the children and the rights that are protected by New Hampshire law for the children. And so those statutes that are focused on the child's rights don't often get brought up.
And we're going to continue with questions if there are any. And do we have any? Representative Smith.
Thank you very much. You said that your organization was created by the Supreme Court?
No, New Hampshire has a statute that if to create a legal services nonprofit providing legal services to the indigent, the New Hampshire Supreme Court has to approve that agency. And so we're an independent nonprofit agency, but we were approved to operate by the New Hampshire Supreme Court in late November of last year.
Thank you very much. Can you tell me where your funding comes from?
Right now, our funding comes from private donations.
Exclusively?
Exclusively at this point, yes.
Thank you. Do you recognize any overlap with the Disabilities Rights Center?
Our founder, Lisa Wolford, who is the executive director, is a former attorney at Disability Rights Center, and that's an organization with whom we coordinate quite a lot and speak quite a lot. Disability Rights Center often represents children in special education matters, and so that's an area in which we have overlap. They don't often represent children in abuse and neglect proceedings.
Thank you.
Any other questions? Representative Long.
Thank you, Mr. Chairman. The 36 states that have appointed attorneys, is there an age that's a commonality where they would start appointing?
That's a good question. And I don't know the breakdown of those 36 states, but I believe that that is sometimes a common area where states will say children or youth at a certain age shall be given counsel. So some states do cut off things in terms of age. And I think that there is some, that makes sense because children have a hard time expressing their own interests, and to appoint an attorney to represent them, that attorney would be appointed to represent their expressed interest. And for children who cannot express their own interests, that would be a hard relationship to work through.
Great, thank you.
And thank you for your testimony.
Thank you.
And the chair would like to ask the researcher, since we're going to be doing a 535 work session, HB 535, have I asked you my usual question of what do the other states do yet? Okay. Could you send me another one? Thank you. And the chair recognizes the Honorable Dan Itza, an alumnus of Children and Family Law. Many terms on that body, right?
Merely 8.
Merely 8.
Thank you, Mr. Chairman, members of the committee. I'm honored and pleased to be here. For the record, I'm Dan Itza, and my residence is in Manchester currently. Since the issue is one of court procedure and adherence to the law, I'm going to take to the liberty of speaking to you about a case of which I know intimately. Some of you may also know it, but I'm going to refrain from using any names. There is a member of your body who was accused of abuse and neglect in regard to medical treatment. DCYF got involved, and in the proceedings of the case, they violated statute repeatedly. First of all, they failed to meet statutory deadlines for when the permanency, for the after the ex parte hearing, you have your first hearing. That was not held within the statutory requirement. Other statutory deadlines for subsequent hearings were also missed.
Were reasons given?
No, not to the best of my knowledge. And I was in intimate discussion, yes.
Yeah,
Well, no, okay.
I know. Yes.
You said they. Is this DCYF?
DCYF.
Or
Well,
is this the court?
The court actually failed to schedule within period required by statute. I suspect that is due to a lack of adequate number of judges. And I, for one, am an advocate for there being more judges, as strange as that may seem. I think the reason that there is a state of New Hampshire is to punish injustice and to provide equity better than the people could themselves if there were no government. Mm-hmm. And to the degree that you as a government fail to do so, you failed your first purpose. And if more judges are required to achieve justice, then more are required. And I would, different topic, but in 2006, I was pleased to achieve my first passage of legislation. And it was to require that in DCYF hearings that all evidence be submitted 5 days before the hearing so that there was adequate time for discovery. The court failed to enforce that. And in this particular case, there were in fact reams of data transmitted to the defense at midnight before the hearing. Obviously, the ability to even see if this was relevant material was inadequate. Now, this isn't a sore loser complaint, because in fact, they won the case. And the judge in the end said, this is a wonderful family, this should never have happened.
So even the judge, him or herself, attested to.
Yes, and that is a matter of the court record. But the problem is that the judge in the process did not enforce the statute upon DCYF and make sure that the defense had adequate discovery. Now, one of the reasons in respect to the previous speaker, the family made the effort and expense of obtaining independent legal counsel for the child. And I think that was probably key in the outcome of the case. And I think he would, the parent would be inclined to introduce legislation to that effect, that such should be the norm and available, and that there should be a stated opportunity for the family to obtain legal counsel for the child. That is, the child is, after all, an interested party in this. If there's really harm, then the child needs to be protected. If it's a spurious case, the child needs to be protected from the state.
Question from
Yes.
the vice chair.
Yes.
Hello, Representative. It's good to see you. Who are you proposing pay for the legal counsel provided for the child?
If the family can, in this case, the family could. I think that would fall to the family. But if the family is indigent and unable to, then just as we have a constitutional right to protection in criminal cases, I think in the case of a wholly innocent party, there's an obligation there on the part of the state. Or private contributions, whatever. GoFundMe pages.
Thank you.
I'll give you a couple more minutes because I've interrupted you during the 5.
No. I just want to encourage, I'm going to tell you one thing that happened to me very recently, and this is really why you are here. Given the frequency of divorce, etc., in our society today, virtually everyone in this state has been before the family court or knows someone who has been before the family court. And therefore, the family court is the face of the judiciary in New Hampshire. The people's opinion of the family court is their opinion of the judiciary as a whole. And at its foundation, this is all about preserving the reputation and honor of the court. Having just returned from wintering in South Carolina, I took the opportunity to go back to my town of Fremont to get my car inspected and my truck. And as I was there, I met one of my former constituents who was also getting his truck inspected. And I introduced myself, and then he thanked me for having been his representative. And I said, well, I'm still involved, and this is what I'm going to do tomorrow, be here before you today. And I mentioned the subject matter of the committee being the review of the family court. And his immediate response, like word association response, was, they're messed up.
Would he be willing to come and give specific issue?
I have not a clue.
Okay.
He was just a former constituent. That was
Okay.
a public reaction to the state of the
Much
family
appreciated, but it underscores what we know. And thank you for your testimony, and welcome back to Colden, Hampshire.
court. It's good to be back where the roads are flat.
And I hope you land in the district and run again. We miss you in the House.
I miss being here immensely.
Chair recognizes Ed Bryans.
Hello.
And remember, on point, specific.
Thank you.
Got it.
And thank you, Honorable Committee and Chairman Pearson, for what you're attempting here. I have complete respect, and I really appreciate the fact that that's why you guys have gathered. And I believe you all have the best of intentions.
Flattery and expressions of appreciation do not count against your
Don't
5
count
minutes,
against me.
sir.
Thank you. My name is Ed Bryans. I'm from the Cheshire County. I live in Marlborough, New Hampshire. My testimony may be a little different because I have a functioning and best interest co-parenting arrangement that I've had for almost 10 years now. My family court experience goes back 10 years when a judicial decision was rendered with a favorable outcome. I'll touch briefly on a few key failures I experienced, and will ask the committee to have me expand on a few points if it's of any interest. I'd also like to ask this committee to respect the fact that I have a mutually respectable co-parenting relationship and absolutely do not wish to open any old wounds or rehash old conflicts. I respect my co-parent too much.
Appreciate that. Give us a few specific negatives that we can consider.
I'd like to use my own, just to give you guys a little reference, I'm the chairman of the New Hampshire for Equal Shared Parenting Division. It's a national effort. I've worked with Time to Put Kids First. We've created it's a co-parenting seminar as a tool for the judicial system to use when parents file for divorce or custody. It basically teaches them to make your kids the first priority, not disrespect your ex. I also work, I'm a board member on the MPS board for peer support. I run a co-parenting collaborative group. It's myself and a female that we meet weekly and have people going through mental health issues because of dealing with the family court system, and it gives them a relief. My first distinct point is with guardian ad litems. I believe we all can agree guardian ad litems are the ears and eyes of the court. Their job is to look at conflict, in my opinion, look for any dangers that would deem a parent unfit and unable to safely parent their child. My guardian ad litem and I from the start had an unproductive relationship, likely a conflict of personalities, but I was completely aware her recommendations would weigh heavy in a judge's decisions. I was ordered to pay half of an initial $1,000 fee and then was met with several motions for the GAL limit to increase the limit. I was not being heard and often was hung up when trying to tempt her, and my only recourse was to reply with a motion to deny the increases. As a pro se litigant, I would ask for not, I would ask the judge to charge the GAL for theft of services because she was not doing her assigned job. In retaliation, the guardian ad litem would turn her reports more and more negative towards me. In my place of worship, I found an unsigned ex parte motion stamped with the law office that my ex had retained. It was a joint motion by the petitioner and the guardian ad litem. In other words, the guardian ad litem, as a mutual third party, should never have been a party to a joint motion. So that's one of the points I'd like to point out. After 4 administrative delays and at a full evidentiary hearing, it was the ex parte motion had to do with, they considered me to be a flight risk. That was the imminent danger that was presented to the court. At my full evidentiary hearing, almost 2 years later, it was revealed the flight risk came about from a Facebook post to my father who had been diagnosed with stage 4 lung cancer. He lived in Virginia, and I simply expressed that I would love for him to meet his granddaughter. That took my child from me for 2 years. Visitations, I'll skip that. The advocacy center I went to after being assaulted by my co-parent, before it was the ex-wife, refused me assistance, but instead assisted the convicted assaulter. Through that program, Monadnock Center for Violence Prevention, they then recommended and provided the other party with a lawyer or helped them get a lawyer. It was at that time that the legal expert, this is when my child time was.
You get
is
the
that
30 seconds.
Okay. Basically, probably most important point is during the time as I was getting visits with my child, they were not being met by the other party and contacting the police to help enforce the written court orders. The police would often say that this is a civil matter, go to court, file a contempt charge. Those were never dealt with. That part needs to be strengthened. I have a Texas statute that was just passed that deals with that. I'll hand it in to you guys. So it's sort of a template to address what I was hoping to bring up.
Does anybody have any questions? Yes, Counselor, go ahead. Representative Macbeth.
Thank you for allowing me to ask a question. Thank you for taking it. In your materials that you're passing in, do you have a copy of the Facebook post which you just said, I'd love for my child to meet you, and based on that, the court took away, or your children were taken away from you for 2 years? So do you have that Facebook post and that court order?
I could probably get it for you. This case is 10 years old. Thank you for your question, and I respect that caught your attention. I just recently, last year, had 5 large storage totes of all my court litigation, and I had a bonfire. I was happy to get rid of it. I'm sure it's still court record, and if that was important for you and you'd like to see it, I could get that for you.
Documentations of things are important. People say, do you not trust me? That's not the issue. We want to so be able to verify what you say that when we draw conclusions, it is because we are convinced.
Absolutely.
So, and I would also suggest to you and to Representative Itza on the specific court case you mentioned that you provide to the front the specifics. That way we can check it out. Some of us are familiar with the case anyway. Yeah. Even better. Thank you. And to you, Mr. Bryans, if you could get the information of that specific case where the allegation of impropriety on the courts, again, we want to verify.
Yes, no,
Okay.
and I appreciate it. And it's, frankly, it was in a broader range for you folks too. I see the same thing repeated often because I
Okay.
deal with a lot of family court
And
people.
if you know a few people who are willing to testify and provide specific things about their case and not generalizations about other things or people, we'd be happy to hear them going forward. We're
Understood.
going to be meeting June 6, 20, and 27.
And again, I appreciate what you guys are doing, and that's fluff after I've talked.
Got it. Thank you. And I'm going to give one more shot to Melinda Nicolosi from Cambridge, Mass. Traffic is bad coming north, I know, but not here. Okay, and now Chair recognizes Paula Wormy. You've asked to speak, so this is your chance. I do not. Paula, you are recognized for 5 minutes. We mean it. Give it your best shot.
Thank you, sir. I didn't even bring up my notes. And actually, I didn't have a lot of oral testimony today.
As long as it's specific to the point.
Yes, I wanted to highlight that DCYF court records are not considered DCYF records under the statute, and parents can submit them. I think most parents would prefer to redact their child's name, and certainly I've tried not to give you children's names or even litigants' names in written materials I've given you. These people don't know me, and I don't wish to out them to the committee unnecessarily. Also, with respect to what Representative Itza said, was I'm also familiar with that case. And I'm familiar with the fact that there was no preliminary hearing because the judge ended the hearing when DCYF was finished with their presentation. I don't know the specifics of what was said because that's the one thing he couldn't tell me.
For a fact, you gave us a fact that the hearing was ended abruptly. Okay, we'll check that out too.
Please, but he can't legally give you a transcript. You've made that illegal. So it's got to be his testimony, I think.
We'll worry about that.
Okay. And also, I think some of the speakers here today have been excellent. They've given me ideas for future written testimony.
Counselor, that's not important.
Okay.
Say specifics of a case to us, or you are wasting our time.
Okay. The specifics of the cases are in my written testimony,
And
so
this is
I'll just end
This
it.
is one copy?
I'm sorry. I'm in a living situation where I don't even have room for a printer, and I'm paying for all those copies. I
I'm
can't do
asking you a
that.
question. Is this one copy?
One
or
copy.
10 copies that you didn't staple?
One copy.
One copy. Thank you.
And I also figured out that I can get the committee copies of even old testimony toward the end by putting them on thumb drives, if you're interested. That'll make it easier for everybody to see, and it'll actually be cheaper than paper. So with that, thank you for the 2-week break. endeavor to submit testimony more in a fashion that you can file it in categories in the future. And I'm certain I'll be back in 2 weeks.
If you attest that you will give us specific details with specific objections in specific cases and not side bunny trails, I will call on you again.
Okay. I've had some medical issues this week, and I didn't get to the oral testimony. I would have
Then
endeavored to do that.
You should have pulled your pink cards because you have basically wasted our time.
Okay.
Yes.
I'm sorry, Mr. Chair, but when someone comes to testify, for many people, even if they're experienced, it's traumatic. And I think it's probably not necessary for us to challenge them. And I hope we can keep a slightly higher level.
And Madam Vice Chair, if this person in question were not an attorney and had not agreed to testify with useful information for the first time and went off on a sidebar, I would have responded differently. The chair recognizes Vivian
Excuse me,
Gerard.
Mr. Chair?
Do you have a question? To whom?
My question really is about expectations of some of the witnesses. I noticed that that pile of paper is at least 50, if not 100 pages, and I didn't see that it was delineated or I mean, I don't think the expectation of the committee is that we are going to be able to read documents like that that are not, don't have specific, a table of contents that tell us what concerns. So I don't know. I know I asked you earlier when we were going to get the documentation, because for me, my memory isn't so good. I kind of need to get what they're giving us then. And also I'm concerned about getting that much information in 2 or 3 weeks and then not remembering what the testimony was. It isn't as beneficial as it could be.
The chair would like to ask a member of the committee to skim through it. And if it, to the degree and where it contains specific things about specific cases that we will then consider as we make recommendations, we'll keep that. The part of it that is not relevant to us, we'll still keep, but we'll flag accordingly, so that when we go to read through things, we will be reading through the things that are important to us, lest we miss some of them for being bogged down in things that are not relevant. So I was going to ask this later, but I'll ask it now. Is there somebody who would like to take a quick read through that and do the relevant versus other matters delineation?
It looks like she.
I'm sorry? Yeah.
Thank you, Mr. Chairman. It looks like she did give specific topics in here, and then she also gave printouts of examples of the things that she was suggesting or alleging were issues. So
Okay.
I think she just provided a lot of information in here, but she did provide like some covers over the different things as I'm looking. I believe, correct me if I'm wrong, Attorney Worm, it looks like that you provided some specific things that you thought should be changed or were problems, and then you provided examples of them and some case studies.
To the degree that is true, then you clerks can go through it and separate them by the specific topics and somehow get them into the relevant folders for consideration. And it looks like there's a lot more wheat and a lot less chaff than I feared. So thank you, and thank you for doing that. Chair recognizes Vivian Gerard. The poster child of copies. You've come to my other committee well armed with printouts in multiple colors sometimes. We will not hold that against you.
Good. Thank you, Chairman and members of the Chair Committee. I'd like to thank the Judge Ashley that came in earlier, because she actually proved my point. These agencies come into you today and tell you what they're paid to be telling you. They're not telling you reality of what happens in the real world. And they just tell you to go get an attorney. And I feel like she was specifically painting myself even as this picture and making you feel and look like an abuser to lose your children. And as I had provided to the committee in the past, and it's actually in the packet that you have right there, I have proved that the judges were biased and they were disparaging me in my case. The transcripts were modified. There was false DVs, false DCYF reports, false police reports that proved harassment just in that JCC report that I gave you, which is page 2. You will see that these judges allowed constant harassment in my case. Even though I went to the Supreme Court on 5 appeals, you got a different outcome depending on different judges. And as we all know, we've had a series of bad judges in our system. But the fact that if any one of us had child support and it went to the appeals, who is child support? Who in child support allows your case to be put on hold when you're supposed to be getting monthly child support obligations? And I'm not the only one. In that package, I believe it's the last page, I gave you Genevieve Ward's child support obligations as well as myself. Both of us.
You have done this with her permission.
Absolutely.
Okay.
And as you can see, that only goes up to 2022. And she has, to this day, over $100,000 in arrears. I was very lucky. I had Judge Curran that was amazing, trying to make use of my case because of the way it's come out to fix these things. But BCSS has different categories, whether you're Title IV. What they don't tell you is not every case is an enforcement case. That some cases end up being a collection agency. And they pictured me as a non-Title IV case, which again, you don't know these things until you don't know them.
And to interrupt here, you're giving us broader statements, but the documentation is here.
Yes.
That will say where, when, what, how, who, that we like.
Better than that,
Okay.
I emailed you, I believe it was a 15-page document last week after our last hearing that said facts and background, which was every single date, every single situation, and who the judges were on that particular document. It's about 4 inches of actual backup information, and I only have a small amount with me that I just presented to Judge King recently. So everything that I tell you is true, and I have a document that backs everything up.
That's the secret word.
And I gave you every document listed on that facts and background, but if you want further, I could certainly provide it. But what I'd like to funnel back to is with child support, they treat people as a collection agency, and not everybody knows that. And if you're not considered a Title IV, they do not do any enforcement whatsoever. And in my case, I got the letters of wage assignments being supposedly taken. I got the enforcement letters, and all of that was provided to you with dates and who provided it. The problem is, if you have this Melissa Pence in Mesa, which is their legal department, this woman put my case on hold just as she did Genevieve Ward. And Genevieve Ward cannot take the time to come in here today. But our cases are so very close because they changed the court orders, they put the cases on hold, and it appears that they have more power than these judges have.
Did they provide reasons for putting them on hold?
Yeah, they told me that because my case was in appeals, which I've been in the court system for 9 years, so that just tells you where my child support has been on hold for 9 years. And the fact that they're changing these orders around, and on my case, which I gave you, they come up with these positive balances with no explanation. So that it looks like you got all these credits on your account, and when you challenge that, you ask for an audit, you ask for a supervisory review, you ask for the judicial hearings, and I even asked for a right to know, which I also gave to you. That was in March. I've been asking for this since 2016.
There is no procedure for while something's under appeal, the money to be paid into an escrow account?
Nope.
To
Nope.
be
They just
returned-
stop everything altogether. And whatever was the previous one that nobody argued on, and in my case, it was in the amount of $533. So in 2021, it's changed many times along the way, but 2021 is when we finally got it to the point that my case law
30
was into effect. But the point being here is, even like when I request the right to know, the process I use from Matt Ruthia, which you'll have his testimony as well, he got his information, I didn't get mine. But it just seems weird because BCSS says that they have no interest in these cases, and I just don't see anything that's consistent. I don't see that what they're telling us is true to their word.
Okay, good. Thank you, thank you, thank you. Now, a couple things. First of all, Ms. Ward, you referenced, who couldn't be here, could she send us a 1 or 2 pager with her specific case? So it's the same kind of deal, but with the specifics listed so that we could put that in the folder. And secondly, anybody have questions? I want to compliment you. This is usable information. This is stuff that's going in the folder to be considered when we look at specific things. So thank you. I used white paper too. Thank you. Chair recognizes Randall Collier from Surrey to come on up, if that's you. To the last person on the end. You know, if this was a quiz show, I'd say come on down, but you may address the group. You're going to need to turn the mic on.
Good morning, Special Committee. Thank you for hearing me. Randall Collier from Keene. Just want to give you an update from my common law writ of certiorari that I submitted to Supreme Court last month. They actually denied the appeal for the false allegations of domestic violence, and that was the paper that I gave you now. Was the Supreme Court rules for extensions for reconsideration to file the appeal. Supreme Court said it was discretionary because it wasn't within the 30-day window. However, it had all questions of law in it. And I was just curious. I'm not really familiar with the DCYF part, but if the judge takes the kids away from the DCYF for abuse, does that go to a criminal court or does that stay in the equity court? If anybody has an answer to that later on, I'm not sure. But if it is criminal court, then why is it separated when they separate parents in equity court without abuse?
It's a good question to find out.
And I just wanted to give you the
Yeah,
extension,
appreciate
but any questions?
Any questions for Mr. Collier? To dovetail on that question, I wonder sometimes too, because when you start making some serious accusations against somebody, that can slop over into a criminal complaint. And yet the rules are still family. I mean, there's a gray area there that needs to be addressed, in my opinion. But that's just me. Okay, Madam Vice Chair, it's all yours. Slide on over.
The chair recognizes Dana Albrecht.
Good morning, Madam Vice Chair. I just wanted to follow up with a very positive suggestion that I heard last time from Ms. Partello involving offering more support staff to judges, possibly in the form of clerks, paralegals, and whatnot. In support of that very positive suggestion, I'd like to offer a specific case slice as to why I believe that's really necessary. You've heard testimony from Ms. Silva about a wonderful jurist. I've sat through many hearings presided over by that officer, and I think he does a wonderful job. But in my case, he was simply overworked. And the issue I'm raising is a very poor order from an otherwise very good judge. Quite specifically, on December 18th, 2020, which is a Friday, the other party filed a motion for an extension of a protective order. It was not even marked ex parte, and by Monday morning, that was sort of rubber stamped and granted. Certainly, I have a remedy on appeal, and was able to get a positive order out of our Supreme Court regarding that. But I would respectfully suggest, rather than go through all of that, just having some more resources where he had time to actually read that, where he had time to hear from both sides, where there was time to really figure it out before it went up on appeal, might have been a much more cost-effective and better remedy. And I would also remark, again, with regard to this jurist, before the joint committee where Chief Justice McDonald gave his presentation, you also heard testimony from Ms. Ortolano in which she won her case before this judge, yet filed a complaint anyway, simply because it took so long. And that's just there to support that these good people really need the resources they need to get it right at the trial court level, so that an appellate court doesn't have to step in and fix it. And I think that's about all I have to say on that. I can get you a copy of that specific order. Again, Friday, December 18th, 2020, granted Monday, December 21st, 2020, without any input from the other side. And to this day, I still don't even know the reason it was granted. There was no narrative. It just says granted. And whereas the statute says the court shall state in writing, its reasons are reasons. And we never got that. And it's 2.5 years later. And again, it's about overwork, I think, on this order, not about any sort of malfeasance on the part of the judicial officer. With that said, I'll take any questions.
Thank you very much. Are there any questions from my colleagues? Yes, Representative Long.
Thank you, Madam Chair. When you referenced the 2020 and the granted on the 21st, I thought I saw something familiar to that you had already submitted with us. Was that already submitted to us?
No, that's not something I've submitted.
Okay,
This is separate. I'll need to submit it, and it's essentially a specific slice to really support Ms. Partello's testimony from the last hearing.
All right, thank you.
Thank you. Are there any other questions? Thank you again for being here, Mr. Albrecht.
Thank you, Madam Chair.
The chair recognizes Robert Tangway. Excuse me, you just turned the mic off.
I thought I understood what was going on. Thank you, Madam Vice Chair, I believe, Smith. My name is Robert Tangway. I would like to thank you all for being here. This is very important. I have a two-pronged testimony. One is going to be about my personal experience in my life growing up as a fatherless child. And the second will be my experience with the court system now, how they are not following rules. I've been looking up the specific statutes.
I respect the importance of your own life experience, but here we need to focus exclusively on the family court.
Right. So,
Thank
and,
you.
and I understand, Madam, and I believe that is relevant. In reference to Mr. Albrecht's testimony, I believe it's kind of the 14th article of the New Hampshire Constitution. Remedies are to be free, prompt, and without denial. So basically what's happening is the court is overworking, and you will find that this is for specifically at pro se individuals. And so that's something that we need to work into. I'm going to ask this group to actually have me come and speak for a period of time, 30 minutes, which I will provide actual facts and a report, and I will do that in writing. So specifically to answer Madam Chair Smith, what we have is I looked up 173B, and the court has issued orders specifically that are in violation of 173B, Section 3, and the opposing counsel, who never even filed an appearance in either case, which is a violation of the court rules, recommended that I use Our Family Wizard, which would violate the protection order. And if you look at 173B, Section 3, it says, if either party wishes the defendant to be excused from any provision of an order of protection, the remedy is to petition the court for modification of such order specifically. So a court can't give out another order. They must modify the order, which is sent to the police. And by the way, I did not commit domestic violence. So there are many such orders, things that have happened, and I can provide the specifics. Everything I say, I can back up in paperwork, writing. It's with the courts. They're just brushing us aside. So myself, in relation to today's testimony, my mother left my father when I was 1 month old. I did not meet him till I was 14 years old. He died when I was 18. I had no relationship with him. I worked down the street at Radio Shack in Concord when there was Radio Shack on Main Street. I know the state. I know this world, and the pain that I went through not having a father is the most important. I mean, it's so hard. I had all the ways that I would present that testimony, and I've cried by myself. But we have everybody who's testifying, they want to be part of their children's lives, and they do not want to be here. No one wants to be in court. No one wants to be here. And that's why I honor you for doing the job that you're doing. But they've been besieged by a profiteering type business that is, everybody does what is in their own perceived best interest. And when women or fathers, it's usually the person with the better family that gets the children. Whoever can demonstrate that they have the most money, legal resources, and I've seen it.
Could you provide documentation for that, please?
Yes, I could. We could do a study, and it would be simple.
No. There was a president a number of years ago who had a very good rubric which he operated under. He said, trust but verify. We need to verify. What we need from you, understanding that each of us, you and each of us, have had our own life experiences, and they color how we see things. We understand that, and it's important, and in no way am I minimizing it. But here we are looking at how the family court functions. And we need to know not what your life experience was, not what your predisposition is, but just the facts. We need the facts that show us where the court is doing a good job and where the court is not doing a good job, where we could do something to correct those problems.
And I understand that. So I made several recommendations, and that's why I do ask that I am given more time to present, such as the lobbyist that presented last week for the domestic violence lobby. She was a lobbyist, and she said some stuff. I believe people are actually trying to do things, but I have everything that I'm saying to back up. There are studies, and in my own experience and filings with the court, I have created a record which verifies such. But I can understand how we need actual facts. And the court is being presented with such facts, and you'll see that when they're presented with such facts, they don't know the law, they violate the law, and do so at the expense of pro se litigants because they can get away with it.
Could you show us the documentation, please?
Certainly.
Thank you.
You're welcome.
Yes.
Thank you, Madam Chair. Just a clarification question, please, and thank you for taking the question.
Yes, Ms. Ball.
I thought I heard you say something that the court ordered you to follow an order, but was that in violation of a restraining order? I missed
Yeah.
something somewhere.
Yes. It was in violation of the protective orders. They've actually held me in contempt. There's an order of contempt for not filing, and I filed multiple papers saying, hey, I can't do this.
So we're, just a clarification.
Certainly.
So were they asking you to use a communication app?
To have
Is that what
direct
it was?
communication with the protected party without changing the order. And then I did send a motion, objection, and I have the index numbers too. So I have all the index numbers. And so, yes.
Thank you for that clarification.
Thank you, Ms. Ball.
Are there other questions? No? Time?
Okay.
No, 5 minutes.
I actually have a book. It's called Incentives in the Environment, and basically and it's published and registered in the Library of Congress, and that can be given as testimony too. And what I've determined is that people do what's in their perceived best interest. So what I'd like to back up is that people are doing what's in their perceived best interest by bullying people who have less resources, which is in a violation of 461A, which was made in 2005 by this body and has sustained. I don't think that the laws per se need to be changed. They're just not being followed.
Thank you. Thank you very much for that clarification. I appreciate you taking the time yet again to be here. The chair recognizes Vivian for Dave Smith. And is Dave Smith here? Why don't you come and just sit there? Thank you very much, Mr. Smith.
Thank you, members of the committee. And I'm not going to say this as well as Dave, but he's not a very good public speaker. So back on May 9th in 2013, Dave was actually a victim of a domestic violence. He did have some of the judges that we've all experienced over here, and he can obviously verify if I misspeak here. But in his case, he was brought in as a defense on his domestic violence, and the judge actually was trying to find abuse where there was none. And unfortunately, as we all know, that once you are classified as this painted picture, you lose everything. And unfortunately, with Dave, he lost all of his property. He lost his rights. He lost everything that he owned. He was in a situation that he had to sign over his property, and unfortunately, he feels like his constitutional rights were lost at the very beginning. And as everybody can tell you, that once you're a domestic violence victim, whether you're man or woman, it's one quick phone call and your rights, your everything that you've ever lived for is gone. It's changed.
Could you help me just clarify, when you say a domestic abuse victim, do you mean that he experienced abuse, or that he is a victim in your perception, or his position, a victim of the system?
So, if I may try to clarify that. So, I was in a unique situation, and I appreciate what Representative Ball said a few weeks back. There are guys who are victims of domestic violence. I was actually assaulted by my ex-wife, who's larger than I am. And she was able to craft and I did nothing. I walked away. I'm a man. I'm not going to complain about it, as many guys do. So I walked away, not knowing that I was going to become the moving party in which the moving party pays. And she was able to then file a 173B against me, which put me in a complete defensive position. I had a home-based business at the time, and the statutes essentially pulled me out of that, away from the kids, away from the business. It shuttered my business completely and put me on the receiving end of everything, and not even being able to go through a divorce. I was in survival mode the entire time. And when we had our first domestic violence hearing, my ex-wife couldn't come up with a good story. Judge Introcaso asked her, where's the abuse? I need the abuse. And she expressed that she couldn't remember what Bridges had told her to say. So then Judge Introcaso, well after our allowed 30 minutes, Judge Introcaso demanded that she have an example of abuse. And they did a little sidebar, and her attorney said that I sat on her 8 months ago, and Judge Introcaso said, well, there it is. And that was it. I was done. It was a good old school mafia shakedown from that point on.
Thank you very much for that. And you do speak quite clearly and well, so I don't think you have to apologize for that. And
Appreciate that.
It's my understanding that the judge is no longer on the bench, and that the judge was removed for cause.
Yes.
And that therefore, at least in this particular case, in the cases involving that judge, the system worked, although it did not necessarily work to your personal benefit.
After I had been steamrolled, the system did work. However, I have no remedy to recover anything that I lost.
Thank you.
And it's just, it's telling that when you go in as a pro se, I know on the orders at the bottom, it gives you your notice of appellant rights. I would like to see a whole form or 2 pages of a form which tells you all the other things. I didn't know about JCC complaints. I'm from 2013, and I think I'm one of the earliest ones in our group to have complained against Julie Introcaso, and Marital Master Del Pra, who said, I don't care how your kids live. I had hearings where I was brought in on ex partes, self-represented with her well-financed attorneys, and I wasn't allowed to speak. And the Marital Master Del Pra would drop his glasses to the end of his nose and look at me, and the entire hearing went without me saying a word.
Thank you. And what happened to the marital master?
He has been removed as well.
Thank you very much. Anyone else have any questions? Mr. Smith, we share the last name. Thank you.
I noticed that. No relation. I've
They're
explained that.
very few of us,
Yes.
of course. Thank you very much for being here and sharing your story, and your suggestion that there ought to be a more detailed and clear discussion about the possibility for what happens next, including appeal alternatives, is something that I think the committee would consider a very helpful suggestion. So thank you for being here.
Thank you for your time.
And I'm going to give you his testimony.
Of
in writing as well.
course.
Okay.
That exhausts the pink cards that we have today. Is there anyone here who has not submitted a pink card, who has not spoken, but would like to speak to the committee now? N-
Thank you for the opportunity. My name is Gail Drobat from Amherst, New Hampshire. These are
From where?
Amherst, New Hampshire.
Okay.
Just a few of the laws. 633-4 is interference with child custody. And if you read that, I don't know if any of you guys have read this before, but it's a criminal code in every state. When a parent goes to get relief, when a parent is interfering with child custody, they're told to go back to family court. It's a civil matter. It is a criminal code. We need codes enforced in this state. This would relieve the courts of being overburdened with these issues, and it protects children. It protects children to have a right with both parents. So that code needs to be enforced. Whether law enforcement needs retraining on that, I'm not sure what the remedy is, but we need to look into that if possible. And the next page is guardian ad litems. If you see 461A16 regarding guardian ad litems, 2019, January 1st, they changed the laws. Guardian ad litems are no longer to make recommendations to judges. It shows bias, and we heard the guardian ad litem board speak a few weeks back, and he said, he kept repeating, the guardians make recommendations. It's in the law. If you go in, you get court orders. They always say with the guardian's recommendations, it's against New Hampshire law. They cannot do that. So again, we need enforcement of these things. We've had several parents testify about fees for guardian ad litems. They're paying $10,000. The guardian ad litems are allowed since 2019 23 hours to do their investigation. How are they making $10,000 in 23 hours? So if we can...
Could you just give me the citation for that 23 hours?
Yes, it is 461A 461A 16 4 or 5 4 actually 4B. They have an hourly rate, a maximum fee for the appointment that will be established in writing. The hourly rate will be no more than twice the fund of a state-funded case, which we don't do anymore, but I think that fee was $90 the last time I heard. So unless the parties agree, they can't go over 23 hours. And then if you go down to 5, it also says they can't exceed their fee cap or provide services without prior approval from the court after a hearing.
I noticed that this printout does not come from the RSA or the supplement. Has this been changed since the state no longer pays for the GAL?
I don't understand your question.
Representative Vitzi.
If I may clarify, I actually wrote the amendment to clarify that statute. It's not been changed. The purpose was, though the state no longer funds GAL, the purpose was to limit GALs to the same extent that state-funded GALs, if they existed, would be funded.
Right.
And that it could not be, they could not go beyond that without agreement of the parties and a confirmation by the judge, and that if they did so, all of their activity was donated.
So this is the 2018 amendment. Thank you very much for that clarification.
So, oops. In particular cases, I know that's not happening. They're exceeding their fees without hearings. I know a specific, and I will provide you the information for this. I don't have it today, but she was suspended and terminated and continued to work, and the parties had to pay. So there needs to be oversight somewhere. There was a complaint to the GAL board. They found no wrongdoing, and I'm going to present all that to you as well. So I'll save that for another day.
Thank you very much.
Thank you.
Thank you. Yes. I'm sorry, Representative Ball.
Thank you. It's not really a question, but if you wouldn't mind filling out a pink card now, just so we have it for record. Thank you very much.
Okay, not seeing anyone else. I'd like to remind everyone that this committee will not be meeting next Tuesday. We will meet again on June 6th at 9:30 in this room. And the session is closed. Thank you.